The search warrant was clearly in breach of the law, because under the law, when you go for a search warrant, the warrant must say exactly what it is that you intend to do. And when you look at this particular warrant, they took things from the warrant, from the house, that were not covered under the warrant. For example, the computers and all these things were not named in the warrant, which you had to do based on the Danai Williams case.
So what was named in the warrant?
They're just some documents.
What type of documents?
Just a document. It was not specific enough, and then they go now and took things that are not covered in the warrant.
Going forward, what we expect come January 23rd?
Well, we have to see the disclosure that they make on us, and but after the disclosure, then we can go further. And go on with the matter, because we are confident based. In fact, when I look at what was being done over the period of time that this investigation was taking place, it is clear to me that the police, they were under pressure to come up with some charge. They were under pressure, and I would not say, but they were under pressure, and they had to do something.
What kind of mood is Mr. Reed and his family in, having been put through this process?
Well, I mean, naturally they'll be feeling a bit down, but I think, having regard to what happened today, in fact, my client, he was in much better spirit today. In fact, he held up well yesterday, but I think having seen and heard what transpired today, he's much better off.
When you say he held up well yesterday,
He never ate anything. He never ate for the entire day yesterday. And so, no, Mr. Professor Pinnock never ate anything at all, and so he was under pressure. But we went through. Over 90% of those questions were not related to the charge.
What did they have to do with? Yeah.
In fact, I had to stop them in their track yesterday, where they were asking questions, because a lot of the questions were not permissible in law, and that is why that particular interview took so long, because I had to stop them on several occasions. That question cannot be asked, and they had to rephrase and in fact abandon some of the questions.
Are they friends, Mr. Reed and Professor?
I don't say they're friends. They went to school together. They went to the same school. No, I don't say that. In fact, in the interview, it emerged that they were asking Professor Pinnock whether or not he was a regular caller of Mr. Reed's telephone. No. All these questions, you know.
But mention was made inside that there were WhatsApp messages that were exchanged.
They were asking about whether that he used to communicate with Mr. Reed by WhatsApp and all of that. And what is significant about I'm glad you raised that question, because let me tell you something. And this is to show that it was a fishing expedition. If they had evidence that Mr. Reed and Professor Pinnock were communicating by WhatsApp or by phone, given the length of time that they had to do this operation, they would have, a proper investigator would have had that information to confront him with it yesterday and say, look here, these are text messages that we get from this phone. Can you speak to it? Nothing was done like that. You get what I'm saying?
Are you speaking though prematurely given the fact that disclosure?
No, what I'm saying to you, because he was subjected to a lengthy question and answer, if they had done their work and had that information, the law is that he should have been confronted with it. Both Reed and Pinnock should have been confronted with those text messages and asked, did you send Professor Pinnock this text? Did you send Mr. Reed that text? That is how the law operates. That you must confront the person with information and get their response. That was not done.